interested in real estate. We know this one. Okay. So, interest in ownership of a parcel of real estate includes all or some of the bundle of rights, depending on the type of interest a person holds in the property. Ownership may be limited by public and private restrictions intended to ensure that one's owner's use and enjoyment of the property does not interfere with the other's use and enjoyment of the property, or with the welfare of the general public. Okay? Okay, so our chapter objectives are to identify and describe various types of estates, explain the difference between liens and other types of encumbrances, and explain the limitations of private property rights for the welfare of the public. Okay? We've got a lot of words here. So let's just read through them. Condemnation. Oops.
Are we, I thought we were in the maroon book.
We're going back to the maroon book later. That's a good question. I'm glad you asked. So we're doing general, and then we're going to go to state.
Okay, thank you.
The reason we're doing that is because generally when you think of the laws, the general laws and the federal laws are here, and the state laws kind of blanket over it, right? So in this particular case, we want to know what the general laws are before we know what the blanket laws are that go over it, okay? But this is the first time we've actually done it where we normally go all through the general and then all through the mass. But I think that, you know, in the spirit of trying to get everything in, that if we do it this way, we get our overlap, like we did like with the block busting, steering, and redlining and stuff, so we can save a little bit of time. And also provide context. So anyway, the key terms to record in this chapter: condemnation, covenants, conditions, and restrictions, deed restrictions, easement, easement appurtenant, easement by necessity, easement by prescription, easement in gross, eminent domain, encroachment, reversionary interest, taking, taxation, encumbrance, escheat, estate and land, fee simple absolute, fee simple defeasible, fee simple determinable, fee simple subject to a condition subsequent, freehold estate, future interest, homestead, inverse condemnation, legal life estate, license, lien, life estate, police power, pour autre vie, and remainder interest. Okay, so there's a lot of vocab in this chapter, okay? So don't skip it. I know it was a lot, and I was like, well, I don't want to read all that, but I just did that with the slide before. I don't want to cheat on you so that when you go back and you look at just this chapter, that we don't have everything in there. Okay, so the three interests in real estate are fee simple defeasible, and fee simple determinable. Hold on one second, I want to see if I go into them. No, I don't, okay. All right, so who has the book open and wants to tell me what fee simple estate is? The definition. Okay, Lindsay?
A fee simple estate or fee simple absolute is the highest interest in real estate recognized by the law. Fee simple ownership is ownership in which the holder is entitled to all rights of the property by law.
Okay. The highest form of ownership is fee simple. Okay, so that will be a question on the test. And they'll also tie this in with freehold and non-freehold, but we'll get there. Okay, so fee simple defeasible. Who wants to give me that? Ann?
A fee simple defeasible estate is a qualified fee estate that is subject to the occurrence or non-occurrence of some specified event. There are two categories of defeasible estate: fee simple determinable and fee simple subject to a condition subsequent.
Okay, perfect. All right. Jim, do you want to read to me what fee simple determinable is?
Yeah. Oh yeah, fee simple determinable is the fee simple feasible estate that may be inherited. This estate is qualified by a special limitation, which is an occurrence or an event. The language used to distinguish a special limitation, words such as so long as, or while, or during, is the key to creating this special limitation.
Okay. So, basically what this is saying is your highest form of ownership, which is you own the house outright, you have whatever, is a fee simple estate. Okay, a fee simple defeasible would be if you had plans for that estate, or how you sold it, or how you gave a life estate, or whatever you did. It would be where it went next, if you will. Okay, and then determinable would be on, you know, if certain conditions were met. Okay, so I don't know if it's going to go into. All right. So I'm gonna jump ahead, and we'll come back to that if that's confusing. All right. So different kinds of estates are estates and land, the freehold estate, a life estate, a port entre vie, a remainder and reversion, a legal life estate, and a homestead. So, okay, I haven't looked at this in a while, so I'm just trying to see how much I spelled out for you. Okay, so a life estate is, how many people have used a life estate before? Okay, Polly, do you want to explain your scenario?
We bought a property and a parent lived in it, and we gave that parent a life estate, so as long as he or she was alive, they could live in that house, and it could never be asked to leave, until which time upon their death, then it automatically reverts to the rightful owner of the property.
Right, so hers,
Same as life rights.
similar, yes. So hers, and maybe even same, I'm not sure. So in her situation, it was a defeasible, because it automatically reverted back to them, okay? They were the remainder men, okay? Now, in a life estate where, let's say, and I think your example is, I'm gonna use just a different example. Let's say that I put a life estate, we purchased a home and we had a life estate for my parents. But I put in determinable that if something were to happen, you know, whatever it was, then it would go to Mariah or something. So that would be that would be the determinable, that if some conditions happened, it would go there. Okay? So that would be the difference on that. Again, this is just definition stuff. So, so that would be your life estate. Port entre vie would be for another, okay? And what's the example that they give in the book on that? Dennis, do you want to tell me?
Life estate based on the lifetime of a person other than the tenant. So,
Okay. So that it's based on somebody else's life, okay? Remainder or reversion. A remainder person is when it goes to somebody else. A reversion is when it goes back to the original owner. Like Paula's situation was a reversion. It reverted back to ownership to her, okay? I think they give you examples of like A, B, and C in the book to explain, you know, how that goes. Remainder goes, it goes to somebody else. Reversions, it goes back. Legal.
They say here for that poor entre vie that maybe someone that's handicapped, physical or emotional, is often used so that it can be in
Yeah.
the next step for them.
Perfect, yes. Okay, so did you hear that the port entre vie would be often if somebody was a handicap or whatever, so that conditions were made for that. All right, a legal life estate, what's the definition of the legal life estate, Dave?
A legal life estate is not created by a property owner, but rather is established by state law. It becomes effective automatically when certain events occur. Dower, courtesy, and homestead are the legal life estates currently used in some states.
Okay, thank you. So dower and courtesy rights have to do with husband and wife, regardless, like, so if one of them died, no matter like whether or not there's a will on it or whatever, the home goes to the other person, or the asset goes to the other person. Okay, they actually have simplified it in Massachusetts, and I think they're all dower rights now, so they're only called one thing. And I got hung up on this to be honest with you, when I was studying for my test, I got like all hung up on, because I think it says like a third of the estate or whatever, and it kind of spells it out kind of funny. Just all you need to know is that for the legal life estates, it's dower and courtesy rights, and that's to your spouse, okay? So don't get all hung up in it. Because I tried to figure it out. I Googled it, I spent all this time, and I'm going like, what am I doing? This is not a question that they're not gonna ask me, it doesn't matter, it never comes up. Which you're gonna find a lot, by the way, when you're studying this. It's like, you're gonna be going like, why do I need to know this? Because this has nothing to do with what your job's gonna be. And that may be true, you know? That's why sometimes, because it's a new book that we're using, some of the words that they use, I've never used, you know? Then I ask you guys to read. Okay, homestead rights, okay, that's who do I want to read about the homestead rights? Tim, can you read to me about the homestead rights?
Sure. A homestead is a legal life estate in real estate occupied as the family home. In effect, the home, or at least some part of it, is protected from most creditors during the occupant's lifetime. In states that have homestead exemption laws, a portion of the land or value of the property occupied as the family home is exempt from certain judgments of debts, such as charge accounts and personal loans, are not a mortgage for the purchase or improvement of the property. If a debt is secured by the property, including funds advanced under a home equity line of credit, the property cannot be exempt from a judgment on that debt. The homestead also is not protected from real estate taxes billed against the property.
Okay, so some people feel like if there's a homestead on a property, and when you sell a house, at the closing, the lawyers will always say to the buyer, do you want a homestead? And they'll talk about what it is, and whether they say is that it protects you from, you know, blah, blah, blah. So this is just telling you what the real rights are of it. What you need to know for the test is it's a life estate, okay? The homestead is a life estate. So the way they ask you in the question is not the way that it's used in real estate when you're at the closing table and the lawyer asks if they want it. It talks about it being a life estate, okay?
It's a good idea, no?
Oh, it's a great idea, yeah, absolutely.
They don't
Definitely.
talk about releasing that, right, in the test at all, releasing a homestead.
Nope.
Most people don't, I don't think they know about it though, when they are buying.
It's funny, more people do now. Most lawyers will do it, a lot of lawyers do it as like their closing gift.
Yeah.
You know, honestly, it's free for them to write up, and they just have to record it with their paperwork, but they look like heroes.
Costs $10.
Yeah, right, well, it doesn't cost them anything, really. I think I would just record it, yeah, so, but anyways, it's a good thing to have. You can ask about it, being done at the, you know, for the closing. You, as a realtor, you could do that. If you have a lawyer that doesn't often do that, you could cover the homestead. Or you could suggest the homestead and look like you're like really practicing your trade and your craft, okay? But just don't over-deliver it, because that's the problem with it. It doesn't cover everything, you know, and it's not like a get-out-of-jail-free card. Okay, encumbrances and liens. All right, so we've got easements, private restrictions, liens, and encroachments. All right. Matt, would you like to read me the definition for the easements?
An easement is the right to use the land of another for a particular purpose. It may exist in any portion of the real estate, including the airspace above, or a right-of-way across the land.
Okay, perfect. Private restrictions. Kim, will you read to me about private restrictions? Are you able to find it?
56.
Private restrictions that affect the use of real estate are often found in the deed that conveys title to the property. Once placed in the deed by a previous owner, a deed restriction will run with the land, limiting the use of the property by the current owner, as well as future owners to whom the property is subsequently transferred.
Okay, so some of those restrictions could have to do with either covenants that they have. It could be deed restrictions as far as, you know, not
A land trust or.
Yeah, exactly. I don't know if they would put that in there as is that yours?
They just did it on mine, yeah.
Did they really?
Yeah,
What'd
the
they
town,
say?
the town put it on the deed that it can only be used as a 3-bedroom dwelling,
Wow,
yeah, on the deed,
on the deed. That's the first time I've seen that. What town?
like
Is it because of septic?
septic, yeah.
Yeah, they're doing that more and more.
They're putting it in the deeds?
Yep.
I haven't seen that. Not so much real estate. Okay, liens, who wants to read to me about liens? Ben?
Sure. A lien is a charge against property that provides security for a debt or an obligation of the property owner. If the obligation is not repaid, the lien holder is entitled to have the debt satisfied from the proceeds of a court-ordered or forced sale of the debtor's property. Real estate taxes, mortgages, judgments, and mechanics liens all are represent possible liens against the owner's real estate.
Okay, awesome. And then encroachments, let's see, what do I want to read this? Wait, would you like to read to me about encroachments?
Where are you seeing encroachments?
Yeah, that's it.
Oh,
Oh, does it jump a little forward?
couple, yeah, okay, sure. When a building, fence, or driveway illegally extends beyond the boundaries of the land of its owner or legal building lines, an encroachment occurs.
Okay, so what they're trying to do with these four examples, thank you, is explain to you what, other than like that little parcel of land you bought with that little house that's on it or whatever, like what other kinds of things could complicate it or could be, you know, something that makes it unique, you know? And then the first thing that we talk about when we do the deed restrictions, which is the one that you had, was covenants, conditions, and restrictions. A lot of times especially if you go into a subdivision or something like that, they'll give you deed restrictions or covenants. And the covenants can be, normally what happens is, when they start a subdivision, they'll have the covenants that were set forth by that subdivision, and they're recorded, and they refer to that recorded area for the covenants. So as a realtor, if you're doing a lot of sales in that kind of, in that sphere, you know, if that's your niche, then you're gonna wanna have those covenants on hand, okay, or in your cloud, if you would. So that way, when you're showing a house in Snippetwood Estates in Rochester, you know, and they say, can I have a clothesline here? You can go onto your phone and you go click, 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 and you send them the restrictions, you know, or the covenants. You know, you can open them up and look at it too to give them the answer, but you're right there giving them the information. So, you know, some of the things that happen, clotheslines, boats, animals, what other things have you guys seen in covenants?
Can't have a business in your
Business
home.
signs.
Business and signs, yep. So those are some things that they could have. Easements appurtenant, okay, now that's the word I can never remember. What's appurtenant? What's
Is attached to the ownership of real estate and allows the owner of that property to use for neighbor's land.
Okay, so the easement appurtenant would be, for example, if you had to drive over, you know, your neighbor's land to get to your house. Okay, interestingly, now if you have this easement, and you have a dominant servient and a dominant tenant and a servient tenant, right? Who do you think would be the dominant there? Because if it's in yours. What, the person driving over? Yes, it is actually the person driving over. So the person who owns the land that's allowing it is serving, this is how I remember it, serving that land to the dominant tenant to drive on it, okay? So the person who owns it, I would think would be dominant because they owned it, but they don't, they're serving. They serve it to the other person, and the person riding over it is the dominant, okay? Okay, easement and gross. Who, Jim, you wanna, let me see, no, who have I called on? Laura, would you like to tell me about easement and gross?
An easement and gross is an individual or company interest in or right to use someone else's land. A railroad right-of-way is an easement and gross, as is the right-of-way of utility easements.
Right, I think of the power lines, that's my example of the easement and gross, like the power lines that go through, you know, where you'll see like an electrical thing that they come on once a year and they check the whatever, that will be also in the deed. Okay, easement by necessity. Who wants to tell me about that? Trevor, you wanna tell me about easement by necessity?
Sure. An easement that is created when an owner sells a parcel of land that has no legal access to a street or public way except over the seller's remaining land is an easement by necessity. An easement by necessity is created by court order based on the principle that owners must have the right to enter and exit their land. Their right of ingress and egress, they cannot be landlocked. Remember, this form of easement is called an easement by necessity. It is not merely for convenience.
Right, okay, so, and we're gonna come back to that one, an easement by prescription. Ben, why don't you read me that?
If the claimant has made use of another land for a certain period of time as defined by state law, an easement of prescription or a prescription easement may be acquired. The prescription period generally runs from 10 to 21 years. The claimant's use have been continuous, non-exclusive. The owner isn't excluded from using that part of the property, and without the owner's permission. The use must be visible, open, and notorious, and the owner must have been able to learn of it.
Okay, so I'm gonna give you two examples that I've run into on this. You're shaking your head.
Because it happened to my parents.
What happened?
They live on Black Island, and before they built their home there, probably the attorney next door who lives in New York City, who knew what he was doing as a land attorney, maintained a portion of the land and then sued them for adverse possession, which is basically what that is.
Yep.
Of the land to make their lot not buildable, which we fought in court, and they were able to still build it via the grandfather rules, but.
He's a sneaky little guy, isn't it?
Nice attorney.
Yeah. The two times that I've seen it, one is in Mattapoisett. There was like over in Topola Lane, over by Ned's Point, there was a little cut through, and people would always walk, cut through there, and to go to the beach, and they never wanted to walk around, so they just cut right through. So once a year, they would take a cone and they would shut it off. They put a cone up and say, do not enter for one day. So then it was not continuous. Okay, now so that would be how they made it so that the land would not be taken over, by those people or by whoever, that the land would continue to be theirs. The other one I saw was, I had a cranberry bog that I sold that was in the middle of, it was landlocked. It was like there was two different ways to get to it, but when we were trying to establish the easement by necessity to get there, they used the easement by prescription definition, and they said, the owners of this property have used this property every 2 to 3 days for the past 30 years. They have never had any problem or anybody tell them that they can't, and they have to get to their crops that are in the back, and so by virtue of that, the path that the road that they took into that, became by easement, that they were able to use that. So, but he specified, it was the way that they worded it in the deed, which was pretty cool, because they used all of the different criteria. So, and yeah, one more, in Fairhaven. Does anybody know where Doan Street is? Okay, so on Doan Street, you have the houses on one side, then you have like the path or whatever, like the woods over at Fort Phoenix in the back. And there's a cut through that all of the people on Doan Street use, and actually it has a little roped thing, and it's like a little sidewalky thing to cut through. So the person who owned that land wanted to develop it and put houses up. And the residents of Doan Street said, no, that's ours because of easement by prescription. We've used it openly and notoriously. We put up this, it's been uninterrupted, and by doing this, we will no longer be able to do our low path. And so they were able to stop it. So at least that's what the guy told me. I never really verified the facts, but we'll use that as my example. Okay. Wait a minute. Okay, so how do you terminate an easement? An easement terminates when the need no longer exists. Okay, so in our case, like that cranberry bog, let's say that they stopped using that for bogs and they didn't need it anymore. That could be one. When the owner of either the dominant or the servient tenant becomes sole owner of both properties. Okay, so let's just say, in your example, no, actually yours wasn't an easement, yours was.
No, they were suing for that.
That was not very nice at all.
Possession.
Okay, by release of the right of the easement to the owners of the servient tenant, okay? By abandonment of the easement, by non-use of the prescription easement. So those are all ways of terminating it. See, look at Tracy Nelson posted in GH Zone. I wonder what happened today. Okay. Definitions, licenses, a personal privilege given for a specific purpose. So that is what the definition of a license is. It's the privilege that you're given for it. Encroachments are the illegal extensions beyond boundaries of lands. So a lot of times they'll use the example of trees that overhang as an encroachment on the property. I had a house that the hurricane took like the shed and moved it over to the other person's land, and so it encroached on theirs. And they just left it there for like 20 years because no one cared, but then when it came time to sell, they're like, your shed's not on your land, and then lease pending, which is a pending legal action. So that's one of the things that gets checked, when they're getting ready to close and have their title. You got something to add? No?
No, I was just gonna say what you said, clearing a title.
Yeah.
stuff must get messy in like old places like Michelle Point and like Salters Point with those property lines and stuff like that.
Very,
Especially when it used to be family, so they didn't care what was on what property and all that stuff. I mean, it's still like that somewhere, but start selling those properties. It must
it's
get
interesting because when you go back to some of the some of the deeds, and they use as reference points like stone walls or a tree or something by the creek, you know, and you're going like, what are they talking about? You know, so it does get tricky. You know, one of the things now is that there's two things that I can say about that. One is title insurance. You know, when you are having a client and they say, you know, the bank will mortgage whatever the mortgage amount is, that bank will take out title insurance for that amount, and then the lawyers will offer the homeowners title insurance for that, you know, for the other amount. And so a lot of times your buyer will say to you, do I need this? So first of all, I recommend you never give legal advice. You know, and you give them the pros and the cons and have them talk to the lawyer about it. You know, one of the things is like in Matt's situation is that title insurance would protect you from the old, you know, the old graveyard, from the old Indian graveyard, or the old, you know.
They're still using it as graveyards there. I couldn't believe that.
Yeah, well, there's
2008.
Well, there was a piece of land that was for sale in Rochester that was like 10 acres, and it was for like $30,000, you know, and it's supposed to be buildable. And it was beautiful, you know, and people were like, why is it so cheap? And the reason it was is because it went through an old Indian trail or whatever, or a schoolhouse, or graveyard, or some sort of something. And so would the person ever come back, or would anybody ever come to claim like the pathway through? Probably not. But do you want to put your house up and then have in front of you, between the thing, something happen, you know? So it was you know, people decided against that. The second thing that happens is that in a lot of places like that, and a lot of the places in Marion, Mass, you'll notice is certified land, which means that the state has certified that it's clear of title things. And so you'll know if it's certified land because in the book and page, it's a low book number. Okay, so if it's like 126 or something like that, if it's a big number, then it's just regular land. Okay, so
Title insurance doesn't protect you from like that Indian thing happening?
you know, I don't think that they would. I don't know.
You don't
I
think
mean,
they'd insure it?
I think that they would say that there could be a problem. There's a cloud on that title, is what they would say. You know, I think that it's. I mean, someone built on it, so someone didn't care. You know, but it was. You know, it was just iffy. But they found that, you know, a few times back. I forget exactly what it was. It was. But I knew it. It was. In this area, we have a lot of this. Other places think that we're crazy. They're like, oh my God, seriously, you have all these problems? They're like, yeah.
Then you have a lot of people that are listed on a deed or a title, and in order to sell, they have to get permission.
Yes.
And sometimes they can't find them, or they're.
Yes, it gets very challenging. You know, we tell a story of something like that, and it's funny because the deed that everybody used as the recorded deed was not the last deed that they had. And so the last deed that they had was to all of the children, and for some reason, and one of the children was in jail in Connecticut, and one of our agents at the time had to drive to get the person to sign it because, you know, the day before, because we didn't even know of that deed until like the very last minute during the title search, because everybody had the other deed as, you know, it was like in the public records, it was that, the one that the people thought that it was, and it was kind of like this obscure thing. So yes, getting signatures can be very difficult. All sorts of fun stuff. Okay, so government powers, police power. Okay, so eminent domain. Okay, eminent domain is the right for the police, the government to take over an area for something they need to do. Okay, whether it's put in a highway or something like that. That's the one that we see most of it for eminent domain. So the right of it is called eminent domain. The process of them doing it is condemnation. This is on every test, and they try to trick you. Okay, the right is eminent domain. The process is condemnation. Okay? Taxation. And it's cheat. So it's cheat is when somebody passes away without any will and without any heirs, and the state takes it over. Okay?
There is a great story in, I think it was Onset, or further out, when they were building the the Bourne Bridge or one of the big roads, there was a lot of land, and they were gonna take it by eminent domain to build the highway, and the woman who owned this great farm bought it. So they actually had to build the highway around it, because she won the
case.
The case.
Well, that's, which is interesting, because they have to show that they have to go through it, you know, technically. And so this particular case, you know, they must have not had as compelling of a case that they had to go through and destroy whatever it was that she had. So, you know, that's interesting, that's cool.
Yeah. So you know what was, so,
Ingersoll, she held him up for
Ingersoll,
15,
that's right.
15 years.
Yeah.
Wow.
She had so much money, she beat the state.
Yeah, most people don't even bother, you know,
Yeah,
because they're like, whatever.
She was well heeled.
Okay, so, does anybody have any questions as they're poking through the chapter? Okay, so you're gonna do the same thing, you're gonna read through the key point review, read the quizzes and answers, are you right, wrong, and why? Go to the quiz bank and customize a quiz on this unit. Take the quiz, recording your thoughts as you did. Send us the recording for you to use for accountability, and text us or email us with any questions. Okay, so let's do a quiz. First question, what I was just talking about. All right, so the right of a government body to take ownership of the real estate for public use is called?
Eminent domain. D.
Eminent domain, good job. A license is an example of a?
Personal privilege.
Excellent, you guys were listening, awesome. An easement appurtenant is?
Runs with the land.
Runs with the land, excellent. You guys are on fire, let's do a couple more. Which of the following is a legal life estate?
Homestead. C.
Excellent, good job. Okay, let's do a couple more. An owner has a fence on his property. By mistake, the fence extends 1 foot over the lot line into a neighbor's property. The fence is an example of a?
D.
Right.
Which one was the,
You got an owner has a fence on his
Okay.
property, the fence one?
Yeah.
Number
Okay,
12.
all right. And this is what you get at the end of all of this. We never even got this far yet, but it's our contact information, okay?
encroachment?